Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. Hello to everyone in between. My name is Dan Balkaran, and I'll be your employment lawyer for the next 30 minutes or so. Just a little bit of housekeeping. As I said, my name is Dan Balkaran. I work as an associate lawyer at the law firm of Samfiru, Tumarkin, which is in my opinion, the leading employee side employment law firm in the country. And if you want to get a hold of me or us, you can do so at employmentlawyer.ca. help@employmentlawyer.ca is the email address. Shoot us an email if you have follow-up questions. And then you can always call us at 1-855-821-5900. For those of you watching on YouTube, hit the subscribe button and the like button. That certainly helps us reach more of you. Okay, great. So I'm going to jump in with your questions, or while I'm waiting for your questions to roll in, we've got one from Tammy, but we're still waiting for the rest. Before I do that, going back months now, almost 5 months, every question or 95% of the questions that you ask me are about employment terminations in the context of vaccine policies from employers and or mandates from the government. So just as a quick reminder, everyone throws the word mandate around and they use it universally, but that's not accurate. It's a specific term. So if your employer decides to terminate your employment because you have not been vaccinated and they implemented a new vaccine policy, then that's the employer's policy, and you likely have severance flowing to you. And we don't know how much without assessing your individual legal position, but you likely have severance flowing to you from that termination. Where that right to severance is extinguished, however, is where there's a government mandate. So government that applies to your sector. So a government mandate would be a properly papered piece of legislation, regulation, provincial health order, something that is not just a decree, by a premier or by Justin Trudeau, but properly papered government order, which says something to the effect of you must be vaccinated to work in this sector. Now, if one of those mandates does exist, your right to severance is effectively extinguished by the mandate. Okay, so that's the difference between the two. And one more thing, I was watching Global News last night, and across the news ticker at the bottom said Justin Trudeau is going to enact measures to help employers or who are being sued for wrongful dismissal for firing, when those employers fire employees for refusing to get the vaccine mandate. I haven't seen any definitive news on that whatsoever. I think that was the news just sort of recirculating something that Mr. Trudeau had said earlier. Even if he did try to do something, it couldn't be retroactive, and it would be limited to federally regulated employees only, which is only about 5 to 10% of the national workforce. So that's it. That's my primer. That's where we're at. Let's see what your questions are. Okay. Lena, how is it possible to? Hi. Is it possible to apply for EI while on a leave of absence due to a vaccine policy? When you say treat leave of absence as constructive dismissal termination, what do you mean exactly? What is the exact process? Thank you. Okay, so the government has said so EI is handled by Service Canada. It's under the federal jurisdiction, and they have said that they are not providing any sort of EI for loss of job or hours due to an employee failing to get a vaccine. So you're going to have an uphill battle there. You would potentially, because it was a change in policy that occurred at Service Canada, but that didn't affect the underlying legislation that the department, Service Canada department, is governed by. So you theoretically would have a right of appeal, but that would, and you might or likely would be successful, but that would take quite a long time. Second part of your question, treat leave of absence as a constructive termination. What do you mean by that? Okay, so the core of your contract of employment, which is, I'm not saying you have an employment contract, but the core of the relationship between you and your employer is you go to work for a certain amount of hours to do a certain amount of duties for a certain amount of pay on an indefinite time scale. Okay, that's the core of your contract of employment. In almost all cases, depending on what's in your contract, your employment contract, your employer doesn't have the right to just stop paying you. The moment it stops paying you, it is effectively signaling that it has terminated your employment. That's what constructive termination, constructive dismissal. It is construed by the law that you have been terminated. That's what they mean by constructive. It's unfortunate. We all mean, the general public looks at the word constructive differently, but that's what it means. So, you have 2 to 3 months. I'd say 2 to be safe. Actually, it's not like you're trying on a change in your employment. You just lost your pay. So I'd move quickly. If you want to claim termination, I would do so pretty fast and say, look, you stopped paying me. Therefore I've been terminated. Therefore I'm owed severance. But whether or not that's worth it for you, right, Lena, because it depends entirely on what your legal position is with respect to severance. There's a huge disparity. If you're entitled to common law severance, which is sort of generally 1 month per year of service, you could have a very lucrative severance package coming to you. However, if you're limited to employment standards minimums, for example, that's 1 week per year of service to a maximum of 8 weeks, roughly speaking. Then it might be better just to sit on your leave of absence and hopefully the cultural and political winds change and you can go back to work, or you decide to get a vaccine, or something changes. So it just depends on your individual situation. And Lena, like I will say over and over again through this broadcast, you need to talk to an employment lawyer. You need to talk to us or someone like us as soon as possible. Shoot us an email if you want to talk to us specifically, help@employmentlawyer.ca, or call 1-855-821-5900. I will say, though, before you do anything, you 100% need to talk to an employment lawyer. Okay, moving on. Mark, are employers allowed to require vaccinations as a condition for newly hired staff? Yeah, so yes. I think that this is going to be, the employer is saying, listen, we have this job, we're going to pay you a certain amount of money to do this work with us, and your employment in that, the nature of your employment that we just talked about is subject to these conditions. Okay, and if you don't like those conditions, you don't have to take it. Okay, just, you don't work here, don't sign the contract, you don't have to work. And so employers now are all going to be, new employers are all going to say, well, listen, we need to ensure that we have vaccine policies built into our new employment contracts, forcing employees to be agree. Well, I shouldn't say force. Employees can choose to agree to the terms of that employment contract, and then they're bound by them. So the short answer is yeah, and that's the tough part for all of you who are losing your jobs because you're not vaccinated. It's a dire situation for a lot of you because you're losing your job. If there's a government mandate, you're losing your right to severance. If there isn't a government mandate, then you have a right to severance tailored to your individual legal position, as I was just talking about with Lena. And the government has taken away your right to EI, and so you're in a bad financial position. But the vast majority of employers now are also going to require that you be vaccinated. So it's and obviously there are regional disparities. Urban versus rural seems to be large disparities there, but it's tough, right? Because it's not like you're going to be able to, let me rephrase that. It's that the percentage, if the reason why you lost your job is because you refused to get vaccinated, getting a new job is not going to be as easy as it was before all this vaccine stuff started. So, okay, hold on a second. Celeste asks, if an employee was underperforming, but then is injured shortly before they were about to be terminated, can they still be fired? Well, this sounds like an employer question. So I think in this situation, the employer is they're in trouble. They can't fire this person. I mean, if that employee, like if they could demonstrate that they had decided to fire her before the injury and have evidence showing minutes of a meeting or something, maybe. But otherwise, the inference that the court's going to draw and the Human Rights Tribunal is going to draw is that you fired this person because they got injured, and so I think the employer is going to have to sit on that person for, well, not literally sit on the person, but is going to have to they're going to have to not fire that person if that's what they want to do for probably a year, at least 1 to 2 years. I mean, or take the hit in terms of severance, whatever that person's severance entitlement is, and human rights damages. So, Randolph, how long can you be legally put on a leave of absence without pay? Well, this is a really good question. So if you're placed on a temporary layoff, which is effectively the same thing as a leave of absence, where they're not paying you any money, and you're provincially regulated, most employment standards legislation has a cap on it. So in BC, it's 13 weeks. In 2020, it was extended from early March to August 30th. Ontario has different rules. They have something called the Infectious Disease Emergency Leave, the IDO, which has allowed employers to place, and I'm called in British Columbia, not Ontario, so I'm not fully versed in the nuance of Ontario statute, but allows employers to place employees in that idle status, sort of, and it has been indefinitely because the government keeps kicking it down the road, and there's been arguments that there's been a couple cases that say, well, that's effectively a termination, and others that say it's not, and I don't think it's been fully decided yet. If you're not in that status, the best thing you can do, I mean, if you're in British Columbia, then you were probably, and this happened in March, you were probably terminated by operation of law on August 30th, unless you were federally regulated. Just generally, to your question, it's better if you've been put on a leave without pay to trigger your constructive dismissal right away. However, to really answer the core of your question, aside from the statutory circumscriptions like the IDO that I talked about in Ontario, I mean, at some point, if you've been on, they're not paying you anymore. At some point, that becomes a termination, right? And so, I again talked to an employment lawyer to see if your individual situation qualifies as a termination. Again, you can reach us, help@employmentlawyer.ca, 1-855-821-5900. Can you go after an employer for severance? Well, it depends on your legal position, Jack. I mean, that I do that all the time. I help people all the time with achieving the severance goals that they want when they've been fired, wrongfully dismissed effectively, which just simply means they were not paid enough severance or provided enough notice of termination. Okay, Dan, great name, asks, I am with, I'm going to leave the name of the employer out, although he specifies his employer. Is putting me on unpaid leave February 1 due to no vaccine. They say that I'll eventually be terminated without a package. Can I actually do that with no package? So my understanding from your employer is that you're a unionized employee, Dan, and if that's the case, you need to talk to your union representative. Your employment is going to be governed to a large degree by your collective bargaining agreement with some overlay from various statutes like the Labor Relations Act. But, if you are not a member of a union, this is sort of the question that we've been talking about. Putting you on unpaid leave is effectively a constructive dismissal, and so you could claim you were terminated by being put on unpaid leave, which you'd want to do if you had a good severance legal position, and then they're eventually going to terminate you. So one thing to think about here is, have they said, if you don't get vaccinated by February 1st, because the date you said, unpaid leave February 1st, and if they eventually terminate, if they give you a specific date of termination, like if they say we're going to terminate you on March 1 if you're not vaccinated, we're going to put you on unpaid leave on February 1 and terminate you on March 1, that period of time is effectively working notice that could be subtracted from your overall severance. So if it was that type of situation, I would see if I could get an exemption if you potentially qualify for one on religious or medical grounds. They'll probably deny it, but at least you muddy the waters with respect to the certainty of the working notice. Potentially, you'd want to talk to an employment lawyer about that. But can they fire you with no package? Well, that's the core of this issue, right? Like, employers all over Canada are firing people for refusing to get a vaccine and paying them no severance, claiming it's just cause. It's insubordination to refuse to get vaccinated. The problem is with that argument is that you were theoretically doing your job, for almost 2 years during the pandemic without being vaccinated. So how can it suddenly be a fundamental term of your employment to be vaccinated? The answer is that it isn't. So a just cause just simply means you don't have a right to severance. So they can pay you zero. And it's a bad outcome for society if you're thrown out on the street with no money and no job. And so the law has evolved this idea of like a severance safety net over time, effectively. It's more complicated than that, but I'm simplifying it. So the law is sort of triggered or structured around wanting you to get severance, but your employer can get away with not paying you any severance if it has a legally justifiable reason not to pay any severance. And so there are three ways to get there. They're all under the just cause rubric. So first way to get there, a single act by the employer is so egregious that the employer is justified no longer continuing the employment relationship. Two, an ongoing failure of the employee to not meet employment expectations that the employee has provided clear warning of to correct and an opportunity to correct. And then sort of a cumulative cause, which is just sort of a general, you're a bad employee and you've done a whole bunch of different things that really justify you getting fired without getting any severance. That third one is a lot harder the more years you've been there. And so on those three branches, it's really the first branch this falls under is the single act of not getting a vaccine so egregious on your part that the employer is justified no longer continuing the employment relationship and paying you zero. I don't see how that's possible, given that you were able to do your job not vaccinated up until 5 minutes ago. I think that's a really tough argument to make, and that certainly you're owed severance. Where the rubber meets the road, though, we don't know this yet because we haven't had any of these go to court, and how judges are going to view them is the judges think, well, it's just judges are on the front line of risk, right? They're on average 65 to 75 years old. And so do they look at things a little bit differently? I mean, I know from talking to people of different ages, you talk to someone who is 65 about the pandemic and they view it very differently than someone who's 30 in terms of risk and measures that should be taken both by the state and by individuals to ameliorate the pandemic. And so, and that's just because their risk factors are totally different. And so do judges look at it differently and say, well, okay, it's not just cause, but we're going to pay you, if you're owed 20 months of severance, well, this guy should have got vaccinated. We're going to give you 10. We don't know how that's going to shake out, but roundabout way of saying, provided there's no government mandate saying you must be vaccinated and you're not unionized, can they terminate you without a severance package, without paying you severance? Probably not. And you should definitely speak to an employment lawyer. Again, helpemploymentlawyer.ca, 1-855-821-5900 if you want to speak to us. Okay. Jennifer, been put on a 6-week unpaid leave for not getting vaccinated. They then told after 6 weeks they may extend my leave another 6 weeks. I have no income now and told because I'm being non-compliant I won't be able to apply for EI. That's correct. Well, you can apply for it, you just won't get it. There's no government mandate for the industry, but the company says they can do this. What can I do? You can trigger your constructive dismissal. I think that, if you agree to the first layoff, can you then retract the agreement and claim constructive dismissal, or are you sort of deemed to have provided your ongoing consent to these kind of to the renewal and the extension of the unpaid leave? I don't think so, because they've taken away your pay. I struggle with the terms unpaid leave, and which they don't have a right to do, and a temporary layoff, which theoretically, if you agreed to it, then because there's no right at common law to a suspension of your of your pay. But if you agreed to the first one, then you're probably bound to the limits of the Employment Standards Act in terms of how much time has to go by, depending on if you're provincially regulated or not. I know this is all very, very complicated. So, short answer to your question, Jennifer, no, they can't just keep doing this if you don't want them to, and you can claim constructive dismissal. No, you don't have a right to EI. Well, sorry, you do have a right to EI, but you won't get it. That's the new government policy. So I would, again, talk to an employment lawyer right away. You can reach us, helpemploymentlawyer.ca, 1-855-821-5900. Take a look at your specific legal position and that your specific legal position and whether or not you can trigger constructive dismissal right now. Okay, Christopher. Sorry, 1 sec. 9-year employee relocated to another province, to BC from Ontario, as they were all working remotely. Let employer know afterwards. Employee was terminated 4 months later. No severance provided. Thoughts? Well, you don't say what they were terminated for. Were they terminated for transferring to a different province and not telling the employer, even though they were working remotely? I think you're so. If the employer knew, this is a really interesting question, actually. So, if the employer knew for 4 months that you had changed provinces, you'd relocated, but didn't ask for their permission first, for the employer's permission first, you could argue that the employer was aware of the change and condoned it for 4 months, and therefore you're owed severance. Okay, because if the employer is aware of conduct by the employee that would be tantamount to just cause normally, but then doesn't do anything about it, it is, after a period of time, deemed to have accepted it. On the other hand, you can't move across the country without telling your employer, right? Because just because you're working remotely doesn't mean, and you may have always worked remotely, but I doubt it because you're a 9-year employee. So, the employer has the right, especially if you weren't always a remote employee, to call you back to work, and say, well, you know what, you have been working remotely, Christopher, but now we want you sitting at a desk. Nothing you can do about that. You don't have a right to work remotely. So I that's a really interesting one. I think there's something there, but I would take a discount in negotiation because it looks bad, right? Like, it looks bad in front of a court. Like, yeah, I decided to up and move across the country because I was working remotely and I didn't clear it with my employer. That's going to look bad to a judge. But on the other hand, letter of law, they knew about it for 4 months. They didn't do anything. So, once they found out, they should have said, well, we're not okay with this. We're firing you, or something to that effect. So, again, Christopher, that's a really, really interesting fact pattern. I think you should call an employment lawyer right away. You can get a hold of us, help@employmentlawyer.ca, 1-855-821-5900. Is 12 weeks of severance low? I got fired for not taking the jab. Was offered, this is Jack, I was offered 12 weeks pay. I was employed for 6 weeks. So, I mean, you're 6 weeks, 6.5 years. You're getting 2 weeks per year of service. Yeah, that is low. But it depends on the unique situation of if you're entitled to common law notice, then, and depending on what your position is, then maybe you have upwards of 7 years, 7 months as your ceiling, as opposed to 3. But the delta, the difference between the two is not so large unless you were making a huge amount of money. So you can certainly kick the tires on talking to an employment lawyer. Depending on what you were making, that might be tough to get a lawyer involved for that difference, particularly because you got fired for not getting vaccinated. And I think that in negotiations on vaccine cases, I think that taking a little bit of a discount is probably warranted. I don't know what this person's name is. Illegal to fire anyone over forcing an employee to irreversibly inject. Sorry, this is not a question. This is just a statement. Okay. Belinda. I think Belinda's been on here before. I recognize Belinda's name. My employer is saying that they can no longer accommodate my shift changes due to school closures. But if working while my kids are remote learning is too difficult, what can I do? Well, I think your employer's got a problem on its hands, because you have, and I don't know what jurisdiction you're in, but most jurisdictions under the Human Rights Code or Human Rights legislation protect something called family status. And if you were working remotely? No, you had shift changes. They had you in those shift changes. and they're saying they can't accommodate you, but if they don't accommodate you, your kids, you're just going to have to lose your job because you have to look after your kids. I think you got something there on the human rights side, irrespective of the severance claim you might have for being terminated. For being terminated, I would assume without cause. So but I mean, Belinda, it sounds like you don't want to lose your job. So if the ideal situation for you is to not lose your job as opposed to going after money, and it sounds like it is in your situation with your young kids and so forth, it might be worth it for you to hire. I mean, I'm always loath to suggest this because once a lawyer gets involved in a relationship, that relationship is effectively torched, right? So, if your relationship with your employer is torched if a lawyer gets involved, but they're going to fire you anyway. Or at least they're saying they're going to fire you anyway. So if you want to stay there, my first thought would be have a heart-to-heart with your boss and see if there's any way that you can figure it out. You can be a little flexible. They can be a little flexible just while this school closure thing is happening. I mean, you got to remember, the employer's going to look terrible in front of a court and in front of the Human Rights Tribunal, talking about how, yeah, we didn't want to accommodate her shift changes because the school was closed and she had to look after her kids. Like, judge is going to bend over backwards to help you in that situation if a judge can. So, so I'd have a heart-to-heart with the employer, your direct boss first, see if you can figure something out, compromise on both sides. If not, you may want to kick the tires on hiring a lawyer by the hour to write a letter saying, if you don't accommodate this person, X, Y, and Z is going to happen to you. Now, I shouldn't say happen to you. This is Belinda's going to take X, Y, and Z action, and here's the downside risk for the employer of that happening. Now, the problem with that, I mean, that might be the only hand you have left to play to keep your job. The problem with it is, of course, if you get a letter, if your employer gets a letter from a lawyer about you, eventually you're going to lose your job anyway, right? Because the employer hates you at that point. So it's a tough spot that you're in. I certainly would recommend talking to an employment lawyer. Well, first thing I would recommend is having a heart-to-heart with your boss and see if you guys can figure it out on an amicable basis. If not, consider talking to a lawyer to see if you can fire a warning shot off the employer's bow that will induce the employer to keep you. And then their third option is after you lose your job, you've got a human rights claim and potentially a severance claim. So I don't know who this person is either. Can I be terminated for not providing a medical form for my leave? I had one, but the return date expired and I am still on leave. But my employer wants an updated medical note. So go get an updated medical note, right? Like, yeah, no, you certainly, like, sounds like they're greasing the skids to fire you, right? They're greasing the wheels to fire you. So don't properly paper your situation. If you say you're on medical leave, but you can't get a doctor's note confirming your medical leave, I mean, you're going to lose your job and you're probably have no severance claim at that point. So I would strongly recommend you get a medical note. Roseanne, how is a non-mandated company able to do this? It's a personal medical choice. It's private. And no one needs to know this. Aren't there laws? Okay, so that protect us from this. What happened to Charter of Rights and Freedoms? I get this question all the time. So it's important to understand, and this will probably be the last question I answer, unfortunately, and I apologize to everyone because these are great questions. Charter of Rights and Freedoms protects you from interference by the government. There are certain, in a free society, if you go back in the history of the West, we had decided in our past that the greatest danger to our liberty and our way of life comes from the state. Okay? It comes from the government, and so we need to restrict what the government can do in terms of entrenching on your personal liberty. Okay, so that's what the Charter of Rights and Freedoms does. Freedom of religion, freedom of speech, freedom of association, freedom of movement. All of those things. Okay, and so there's a catch-all under there, Roseanne, about Section 7, life, liberty, and security of the person. It's very arguable that a lot of these government mandates are in fact illegal, and so they're all going to be challenged, and those challenges are going to make their way up to the Supreme Court of Canada. Our Constitution is comparatively weak, though, compared to our American friends. You can violate the Charter of Rights and Freedoms in Canada if you have a good reason, right? So that puts an unbelievable amount of power in the hands of our, I can't remember how many there are, 7 justices in the Supreme Court bench. And so my view of this is, I suspect most of those mandates are going to be illegal, but I think it's going to turn on what's happening with the pandemic. But when they come to court, like if the Supreme Court, if people are dying in huge numbers from COVID, I think that it's a good shot that a lot of those mandates are legal. But if they're not, and it's degraded to the level of the flu for 90% of the population, then I think that it's a good shot that they're illegal. So, but that doesn't apply to the employer. Okay, that's the government mandates themselves. Your employer can do whatever it wants with respect to you as an employee, subject to your rights. Okay, and so if you are fired for refusing to get the vaccine, your only legal right in the event of your termination is severance. Okay, that's it. That's all you've got. And so you also have some human rights rights that accrue to you under the Human Rights Code. You could make an argument that they're firing you for a perceived disability with respect to COVID, or if they denied your religious exemption. But generally, your only legal right in the event of your termination is severance. So, they have decided to implement a vaccine policy. You find it objectionable. If you don't follow the policy, you're going to get fired. Obviously, that's a disaster for you because you don't want to lose your job. But your rights that flow from you losing your job generally are severance only. Okay, so that's the distinction between the two. That's where the charter falls into play. I know that severance is a poor substitute for your job, but that's the way our legal system is structured. And so, before you make any decisions, certainly, and this goes for everybody, speak to an employment lawyer. You can reach us, help@employmentlawyer.ca, 1-855-821-5900. If you enjoyed today's session, please remember to subscribe to us on YouTube and hit the like button on Facebook. Certainly, we appreciate it. Listen, great questions today, everybody. I really appreciated them. I'm sorry I couldn't get to all of you. I will be back in 2 weeks. I'll be here 2 weeks from today, same time. However, we will have other lawyers in this space next week as well, answering your questions. Please feel free to join us for that. We would love to hear from you. Other than that, I hope you all have a wonderful and safe weekend. And I personally will see you all in 2 weeks. Thank you very much.